Welcome to this Legal Aid New South Wales Law webinar on legal words for interpreters, criminal law. My name is Kerry Wright and I work in the Community Legal Education branch at Legal Aid New South Wales. And I'm here today with Helen Shaw. Helen is a senior solicitor in the Legal Aid New South Wales Criminal Indictable section. Hi, Helen.
Hi, everybody. Yep, so I practice in criminal law in Sydney's the Sydney office of Legal Aid, specialising in indictable matters.
Thank you. So before we start, I want to acknowledge and pay my respects to the traditional owners and custodians on whose land we're broadcasting from today. Helen's in Sydney and I'm down on the south coast of New South Wales. And to extend that respect to any Aboriginal and Torres Strait Islander people joining the webinar today or listening to the recording. So the purpose of today's webinar is to explore common words used in criminal law settings, and we will have other workshops later in the year focusing on family and civil law words, but today is about criminal law words. And this is the slide coming up now is an overview of what we'll cover. So we're going to talk about common words used in courts, the criminal process words, legal document words, words used in criminal law, words about offences, the types of sentences, and where else you can get help with legal words. So that's what we're going to focus on today. And as I mentioned, today's focus is about for interpreters who work in criminal law settings. And Legal Aid New South Wales has a range of services that assist young people and adults with their criminal law matters. And we've got a little poll question that we'll ask you to just tell us about your experience with interpreting in criminal law cases. So how much experience do you have interpreting in criminal law cases? You can choose by clicking on the screen your options. I'll give you some time to vote on that. Okay. So Helen, people are voting at the moment. So I'll just close that and share the results so Helen can see. So looks like a little bit, 54%, but 24%, Helen, say quite a lot, and 22% say none yet, but I'm interested.
Excellent. So well, hopefully you'll all gain something from today's presentation, and as Kerry said, we do welcome questions as well.
Great. So I'll just hide that poll so our slides come back up and move on to our next one. So over to you, Helen. Tell us about these courts.
Okay, so every criminal charge, whatever it is, starts in the local court. The local court's at the bottom there. So New South Wales, we call them local courts, but I know that for any of you that may be tuning in from Victoria, there's different terminology like county court, but New South Wales, it's called local court, and every charge will start in the local court. Majority of charges will finish in the local court, but some will go up to more serious charges, will go up to district court, for example, armed robberies, sexual assault, that sort of thing, and selling drugs. Murder and terrorism, for example, will go to Supreme Court. And if somebody appeals the conviction or the length of their sentence, they can appeal to the Court of Criminal Appeal from either the District Court or the Supreme Court. They can go to Court of Criminal Appeal. And the High Court is the highest court in Australia. It's a federal court across Australia. Very few cases are allowed to be heard there. You need special permission, special leave. It's very hard to get a case brought to the High Court, but that's the highest court in Australia. So federal Commonwealth charges and state charges all start in the local court.
Okay, thanks, Helen. We don't have any questions about that, so we'll move forward. So this is the criminal process, Helen. Do you want to tell us about that?
Yes, so as interpreters, you may get a call to go to the police station or to interpret on the phone for somebody that is in the police station. The person has been arrested by this stage and they've been taken to the police station by police. They've been offered an interview by police, and you might be asked to interpret when the person speaks either to police or to their lawyer, for example, and the lawyer might tell the person that they have a right to silence and they do not have to participate in the interview with police. Okay, so after the person has been arrested and either chosen to give an interview or chosen not to give an interview, the police make a decision about charging the person. So the police will lay some charges. That's the terminology that we use. And then police have a choice. Do we give the person bail after we've charged them, or do we refuse bail after we have charged them? If police give the person bail, then they will be told what date they must go to court, the local court. They'll be given a next court date. If police refuse the person bail at the police station after they've been charged, then police must bring the person to court as soon as possible. So if they're charged on Friday night, they will have to go to court on Saturday morning at the bail court on Saturday morning. If they're charged on Monday morning, hopefully they will make the court during the day on Monday. They go to local court and then the person has an opportunity to make a bail application in front of the local court magistrate. Down the track, after the police have served documents like statements, which is part of the brief of evidence, a person chooses how they're going to respond to the charges. Pleading guilty, pleading not guilty. They're two examples, and some people have a plea of not guilty on the grounds of mental illness, but it's an answer to the charge. What are they going to do? So if somebody pleads not guilty and they either go to hearing in the local court, or if their case has to go to district court or Supreme Court, they go to trial with a judge in the district court or Supreme Court if it's murder or terrorism. Or if the person pleads guilty, then they get sentenced. They might be sentenced by a magistrate in the local court, or they might have to go to district court or Supreme Court to be sentenced, and they get their punishment. Any questions about any of those, that brief outline of steps?
I've just got one question, Helen. Just to clarify, bail in Australia is not financial like in the States. I think
Correct.
they mean USA.
That's right. There might be a financial component in the sense that somebody might have a person, example, a parent or a friend or a husband or a wife who promises to forfeit or to deposit some money, an amount of money, if the person fails to appear in court, then the person that's promised the money loses that money. But you can also get bail without depositing any money. Depends on what conditions are imposed, but it's different to the United States, which we hear, but we see in lots of movies and TV shows where people put up bail for people. It's a profession, like putting up bail.
Mm.
So Yep,
Yeah,
arrest and police interviews. Yep. Oh, sorry, was there any
fascinating.
other question?
Oh, someone's just asked, just popped up, can they delay the bail as they don't have representation?
You can appear on a bail application yourself, or you can, most people will ask their lawyer to make an application for bail to the court. So, but some people represent themselves on bail. But you don't have to make an application straight away. Sometimes people wait until the documents from the police are served, because it might actually strengthen the application for bail. Or some people are waiting to secure an address to go to, or a rehabilitation facility. They might have a drug problem and they might ask for bail to go and live in the rehab facility. That might be a bail condition.
Mm. And there's a few other bail questions, but I think after this slide we're talking about bail, so we might leave them till then.
Not a problem. So the role of police is to investigate matters. They'll ask questions, they'll investigate, and they might charge people, or they might ask questions and choose not to charge somebody. The role of the lawyer is the defence lawyer is to represent the interests of the person who is being accused or has been charged with something. That's the role of the defence lawyer. The prosecution lawyer represents the state of New South Wales, represents the community. Interpreters, your role is very important. It's extremely important role, and you might be interpreting at the police station between police and an accused person. You might be interpreting when the person is giving an interview with police, when police are explaining the rights of the person, for example, the right to silence or the right to speak to a lawyer. You might be interpreting in conferences that the lawyer has with the person at the police station before or after they are questioned by police. And there's also, some people have a support person. Example, a child should be offered a support person. People with an intellectual disability are offered a support person. And Indigenous people, Aboriginal people, are offered a support person. It might be a stranger, or it might be a friend or a family member, but they're offered a support person. So there might be a few people at the police station talking to the client, talking to the person that's being charged. Right to silence is a fundamental, basic, it's a right that we have in New South Wales, that you do not have to speak to police, you do not have to make an interview, you do not have to answer their questions. And in court, it cannot be used against you that you chose not to participate in the interview and answer police questions. So there is a right to silence. And as a lawyer, it's very important that my client understands, no matter how much pressure the police put to answer questions, that the person still has the right to silence. Some cultures do not have the right to silence. Some legal systems do not have a right to silence. And so when I have somebody from overseas that either a citizen or not a citizen, but born in a different country, it may be their first time in trouble with the police in Australia, I make sure that they understand that they have the right to silence, because they might be coming from a country that they do not have a right to silence, and that it is for some reason compulsory to speak to police. So I always emphasise their right to silence. ERISP is an acronym. It stands for Electronic Record of Interview with Suspect, or a suspected person. Errors. The other word is record of interview, ROI, record of interview. So these are video recorded and audio recorded. In the past, it never used to be, but then there were lots of complaints about police conduct. Either some people were assaulted or bashed by police, and you wouldn't know because you couldn't see the face, you couldn't see any bruises, or police would be accused, rightly or wrongly, but police would be accused of saying that somebody made a confession, but the person did not. The person disputed making a confession or an admission. So now, or since at least the 1980s, late 1980s, I think, interviews with police are video and audio recorded. It protects the person and it protects the police from allegations of misconduct. So everything that is said is video and audio recorded, and we get a copy of the interview and we get a transcript. It's typed. We get a transcript of what is said. And those get played in court. If a person goes to trial, the videos get played in court. It's evidence. COPS, C-O-P-S, is a database that police use to type up information about every complaint, about every investigation. Sometimes no charges are made, but they are still entered into the computer system to say police spoke to somebody, did some investigation. Everything is given a number. So if you call police or you go to the police station, you might be given a card with an event number on it as a record of you having spoken to police about something. H number, every charge has a number and it starts with the letter H. I don't know why it starts with the letter H. That's just the number that the police give it. Apparently it doesn't stand for anything. But so in court, especially the local court, as an interpreter, you will hear the magistrate or the prosecutor or the defense lawyer talk about H number. So it is the charge. It will have H and a series of numbers after it, and you'll hear the lawyers or the magistrate say, I've got a set of papers here, meaning documents, ending in H number 6365 or 1234. So every charge has a H number, but there might be several, and the next word is sequence. There might be several charges, criminal charges, under the 1H number. For example, I'm charged with robbery and I'm charged with assaulting a person that I've robbed, and I'm charged with using the credit card of the person that I robbed. So I might be given 3 charges. Each will be given a different number, charge 1, charge 2, charge 3. Those are called sequences. I don't know why, it just is. So you will hear sequence used all the time in the local court. You'll hear the defense lawyer saying, my client is pleading guilty to sequence 3, and the prosecution is withdrawing sequence 1 and 2. A sequence is a charge, and they are the same. So sequence 1, 2, and 3 will be all under that 1H number. It's like a reference number. So there'll be multiple, if there's multiple charges under the one, after one arrest for one thing, then there'll be multiple sequences, sequence numbers. So you'll hear that all the time when you're interpreting in the local court. Plea of guilty to sequence 4 and withdrawing sequence 1, 2, and 3. So just when you hear that, that's what it means. It's a separate charge.
Okay, thanks, Helen. there's one question here going back to right to silence. The person said, I've been told you're legally required to only give your real name and address and nothing else. Is that right?
Yeah, if police ask you for your name and address, like like you're on the train and somebody doesn't have a ticket or an Opal card, or they haven't tapped on and they're asked for identification, a person is required to give their identification. If they don't, then they'll be removed from the train and taken for identification purposes, taken to a police station so that they can be identified, so that they can be charged with not having the fare or not paying the fare, but you do not have to participate in an interview with police. That's the right to silence. So you do have to give your name if asked, but you do not have to participate in an interview with police.
Okay, thanks. So the next slide's coming up, and this is about bail and release. If you want to
Yep.
work your
So
way through there.
yes, I will. So bail they're also called release applications, meaning being released from jail, being released from custody. So bail it's a condition of your liberty. So if you're on bail, that's the best way I can describe it. It's you're in the community under conditions, certain conditions. For example, and there are some types of bail conditions on the right-hand side. For example, you must live at this address. You tell the court where you're going to live. You must report to a particular police station, which should be close enough to your address. You might be banned or prohibited from talking or contacting certain people. Usually, you cannot contact prosecution witnesses, the victim of a crime, or co-accused. If you're accused of doing a robbery with somebody else, you may not be able to speak to your co-accused or phone or text message or email. Don't contact them. Don't associate with them. Some people have curfew. You cannot leave your house between 9 p.m. at night and 6 a.m. in the morning, and police are allowed to go and check if you're at home during that time. So that's a curfew. Surety is a person, example, a parent or a friend, who promises to pay some money if you fail to appear in court. So they may have to deposit some money at the court registry and risk losing that money if you breach your bail conditions. For example, you fail to turn up to court, you commit another offence while on bail. So a surety is a person who makes a promise to the court that they will risk losing this money if the person breaches their bail conditions. And if the person wants to change their bail conditions, like move house, change address, change the number of days per week they have to report, then the surety should write a letter to the court saying, I agree with these changes. And that's in order to vary the bail application, change the bail conditions. There is a Bail Act, a piece of legislation called the Bail Act, and it has changed quite frequently over the years. Bail is decided by first of all, the police can decide if they give you bail or not after they charge you. If they refuse you bail, then you go to court. Magistrate can refuse bail or grant bail under conditions. Some people are on bail with no conditions, but that is also quite rare. But some people do have bail with no conditions. So bail is decided by the court. Can be local court, can be district court, can be Supreme Court. And I'll get to Supreme Court bail in a minute. Show cause, there are offences which you have an extra hurdle where you must give a special reason, which is showing cause why you should not be in detention, why you should get bail. For example, and there's a specific list of reasons, but for example, if you are already on bail and you commit a new offence, allegedly accused of committing a new offence while you're already on bail, then it's harder to get bail the next time. Certain offences might be show cause, like terrorism or murder, certain types of offences. Some people are on parole, so they're still serving a sentence. They're still on parole in the community under supervision, and they are accused of committing a new offence. Then getting bail for the new offence is harder because they have to show cause or justify why they should get bail. They have to justify it. Show cause is like justifying why they should be able to get bail. So there are a list of, in the legislation, there's a list of show cause offences or list of show cause examples. Bail concerns, there's 4 things that the court is concerned about. The risk to the community if this person is on bail, risk of reoffending. So if there's a high risk of reoffending or risk of doing something else while on bail or harm to the community, then what can the court overcome this by setting some conditions? If the court thinks that these concerns can be overcome by setting conditions, example, making a curfew, example, asking a surety to deposit some money, or like another bail concern is, will this person come to court? Will they fail to appear? Let's look at the criminal history. Does this person have a history of failing to appear in the past? If yes, then it's going to be harder to get bail. If this person has failed to appear 10 times in the past over the years, then it's going to be harder to get bail this time. But if the person has no history of failing to appear in court, they've always turned up to court, there's never been any problem, then that's a good thing, and the court may not have any worry that they're going to fail to appear again. So that's a concern. So how can we solve that concern? What should we do? Should we make them report to police twice a day? Should we make them report to police once a day? Should we put a curfew on them? For example, the offence occurred at night time while the person was drunk on alcohol. Maybe we should make a bail condition that there is a curfew so that we don't want that person out at night time, and we ban them from having any alcohol. So those might be conditions which we impose to reduce the risk that they're going to behave in that way again. So those are bail concerns. Are they going to do something which causes the community any harm, causes the court to be worried that they're going to fail to appear or fail to follow the law? What can we do about it? What conditions can we impose? Now, if nothing can stop the worry of the court, then they'll be refused bail. If there's no condition that can reduce the risks, then the court will refuse bail. Section 74 is a hurdle. If a person has already made a bail application in the local court and been refused bail, then they need to prove that there's something new. There's a change in circumstances. What is different? Why are they applying for bail again? What is new? So the magistrate will ask, what's changed? What is new? Why are you asking for bail again? You just got refused last week. What's new? So maybe it's a different address. Maybe police have dropped a charge. Maybe the charge we're facing is less serious now. Maybe somebody has now offered to put some money up for bail, maybe that's different. So there has to be a difference. There has to be a change in circumstances. And if you can't show that there's been a change, you will not even get over that hurdle, and you'll be refused bail before you even start making the rest of the submissions. So Section 74 involves a second or third or fourth attempt at bail. There must be new changes. There must be new conditions. Supreme Court bail. You cannot make an application in the Supreme Court unless you have first been refused bail in the local court. So local court refuses bail, then you can make an application in the Supreme Court. The Supreme Court will not hear your bail application if you have not at first tried and failed in the local court. That's bail. So you may have to appear as interpreter in a lot of local court bail applications and also Supreme Court bail applications.
Thanks, Helen. I think you'll need to just clarify this question that's come through. I'll read it out to
Yes.
you. If I understand correctly, personal surety is a person is used as surety instead of amount of money. If the bail conditions are breached, the person who appeared as personal surety may be charged arrested.
No, a person is a person is a surety. A surety is a person who is offering. They might be offering some money to deposit, or and the money might be called a security. The money is called a security to deposit it or to. But the surety. The surety may need to. You can be a suitable person as well, sort of being like suggesting this. I am telling the court that that the person that's applying for bail, I'm telling the court this person will turn up to court, but they won't arrest the surety. But the surety can lose their money. There is a risk of being a surety. The surety can lose their money.
Yes, but they can't be charged or arrested for the offence that the person.
No.
Yeah. So the other question I've got here is, can you appeal the bail in district court? I guess if you're refused is what they mean.
No, you don't appeal. You can make another application, but you're not. But the DPP can appeal. They can appeal to the Supreme Court against you getting bail in the local court. The DPP can appeal. They can apply to stay, meaning stop you getting bail while the appeal is heard. So DPP lawyers can appeal the bail. The decision to grant somebody bail. The DPP can make an application to stop you getting bail for a minute, and go to court for the Supreme Court to decide whether the court should give you bail or not. But if you want to make bail, you have to make another application, but things should be perhaps different.
Okay, well, this is a good segue because someone's just asked, what is DPP? And I'm going to move our slide to the next one, which is about people at court. So that'll give you a chance to explain what is DPP.
So I'll deal with that straight away. DPP is Director of Public Prosecutions. So there is a director, that's the big boss. That is a person who is appointed by the government. That's the Director of Public Prosecutions. And then the office of the Director of Public Prosecutions employs lots of lawyers, and they are DPP lawyers. They are prosecuting lawyers, and they have solicitors and Crown prosecutors. So you have solicitors at the prosecution, solicitors who work for the DPP. There's state DPP and there's Commonwealth DPP. The Commonwealth DPP prosecutes social security fraud, terrorism, people smuggling matters, offences against the Commonwealth, which AFP, Australian Federal Police, will charge and prosecute. So you've got state and federal, or state and Commonwealth prosecutors. They work in different offices, but you have a director, and then you have all the employees, which are the lawyers. You have Crown Prosecutor, which is a barrister, and they'll be called Mr. or Madam Crown in court. Madam Crown for a woman, Crown Prosecutor, and Mr. Crown. So their surname is not used in court. They're just referred to as Madam Crown or Mr. Crown. Their family name or their surname is not used in court. So the jury just hear them be called Madam Crown or Mr. Crown. So we start on the left-hand side. Lawyer is somebody that has a law degree. Not all people with law degrees practice law. If you're practicing law, but all lawyers must have a law degree, and there's all different types of law, not just criminal law, but the lawyer, both a barrister and a solicitor are both lawyers. So barrister and solicitor are both lawyers. They both have law degrees. The barrister has done some more exams, done what's called the bar exam. And in court, in the district court or Supreme Court, you can visually tell who the barrister is because they have to wear the black robes and the wig, the horsehair wig or the synthetic wig on their head. That's the barrister. The solicitor doesn't wear the wig and the black cloaks. In the local court, though, it's trickier because nobody wears the wig and the black cloaks in the local court, so it can be harder to tell who is a barrister and who is a solicitor in the local court. They might both be doing the identical job, bail application, sentence, local court hearing, but the barrister does not wear their special robes in the local court. Magistrate will be on the bench, sitting up, making decision in the local court, and judge is in the district court, and judges can choose to wear their wig or not, but they normally have a wig. Justice is in the Supreme Court. They're still a judge, but they're called justice, and they're in the Supreme Court. Registrar is in all the courts, local court, district court, Supreme Court, registrar, and they might deal with all the subpoenas. They'll make some administrative decisions. They won't decide if somebody's guilty or not guilty, but they do a lot of administrative work, filing documents, registering documents, listing cases in court, making some orders for filing of documents, and they'll do the return of subpoena list in the district court and Supreme Courts. Police prosecutor is a sergeant of police, and some of them have some legal training, and many of them go and get law degrees as well, but they don't have to be a lawyer. But they will usually get some special training, and they are in the local court, and they will be at the court at the bar table. There'll be a police prosecutor dealing with matters that police are representing, that the police are involved in, and the DPP lawyer there'll be a DPP solicitor appearing for the DPP. So you have police prosecutor and a DPP solicitor in the court, and you have the defence lawyers as well. And police prosecutor will also run defendant hearings and appear in sentences as well, and bail applications as well. So will the lawyer for the DPP. Sometimes the DPP is prosecuting the matter, sometimes police prosecutor is prosecuting the matter. And senior counsel or Queen's Counsel, they are the same thing. When there was a King of England, it was King's Counsel, I don't think there's many of them or any of them now. So Queen of England, Queen's Counsel, you have junior barristers, senior barristers. But some of the senior counsel are not very old at all. You still get some very young senior counsels. They apply to do that, and they're judged on by other lawyers. They're a committee judges whether they can become senior counsel or not. But first of all, they're a barrister, and likewise you get lots of junior barristers who have been a junior barrister for 30 years. They don't apply. They don't all apply to be senior counsel. Senior counsel will certainly charge a lot more money than junior counsel, but essentially they're both barristers and they're doing the same job in court, but the money will be different.
Okay.
Yep, judge, justice, registrar. Yep, I think I've explained those. There'll be different role between solicitor and barrister in court, different role. I can explain the role if anyone wants to know that.
The one question we've got here, Helen, is do we address a registrar as Your Honour?
I think it's just registrar. Yeah, good question. I think it's just registrar, and judges, justices and magistrates are now all Your Honour. There used to be Your Worship, but now it's all Your Honour. I haven't appeared before a registrar for a while, but as far as I know, I think it's just registrar. You won't go wrong if you say registrar anyway.
And you probably don't go wrong either if you call them Your Honour accidentally either.
That's
so
right. They'll probably be happy if you do that.
if you're doing court over court or something.
That's
Okay,
right.
so this is oh, hang on. Someone said, what is the role of solicitor in court and what is the difference between solicitor and barrister? So someone does want to know that.
Okay, so they can do the identical job. That's the first thing. So a solicitor can appear without a barrister, and we do all the time. I go to court, I mention a matter, and I'll explain mention in a minute. I mention a matter, I do sentences, I appear for a client, I make submissions, spoken and written submissions. So does a barrister. In a trial, though, I will hire a barrister, and in the trial, the barrister will do the questions. The barrister will cross-examine witnesses. I will take notes. I will organise all the documents in court. I will not be making submissions when I have a barrister in court. The solicitor talks to the client a lot more. So the solicitor is sort of the intermediary, if you like, between client and barrister. I will organise conferences between client and barrister, which I am also involved in, but most of the time the client will deal with me directly, and I will speak to the client a lot more than the barrister will. The barrister will have less conferences. I'll have the barrister in a bit more closer to the trial date. I'll start getting the barrister involved more. My job as solicitor, when I have a barrister, is a bit more behind the scenes. I've got to get all the paperwork ready, prepare the case, issue subpoenas, do a lot of work for the barrister that the barrister wants. I read everything, I prepare all the documents, make sure the barrister is ready in court. But in court, the barrister will do most of the talking in trial. That's a major difference. If I don't have a barrister, then I will do identical work to what the barrister does, meaning I will make submissions in court if I don't have a barrister. So, yeah, that's essentially, hopefully that helps distinguish the two.
Yes, I think so. And someone did ask also the difference between the police prosecutor and the DPP solicitor.
Well, the DPP, police work for police. They investigate. The police investigate, and then they will have a representative in court, being the police prosecutor. That person might simply, on the day, they might be simply mentioning, and again, I'll get to mention in a minute, mentioning the
Yes.
matter, it's adjourned for another date. Or the police prosecutor might be appearing in sentence. The police prosecutor may not be a lawyer. That's a major difference. They're a police officer. They may not be a lawyer, whereas the DPP lawyer is always a lawyer. The DPP solicitor is always a lawyer. They have a law degree. Police prosecutor may not have a law degree, but some do, and some study law as well, but they don't have to. Essentially, if they're appearing on sentence, they're doing identical. But you don't have them both in court for one sentence. You don't have both police prosecutor and DPP lawyer in court for the sentence. Police prosecutor will not be appearing in the district court. Police prosecutor will not be appearing in the Supreme Court. Police prosecutor only appears in the local court, whereas DPP lawyer may appear in all courts: local court, district court, Supreme Court. So hopefully that explains the difference.
Yes, and one of the last questions is the counsel also a lawyer? Like you talked
Yes, the
about Queen's
counsel is
Counsel.
barrister. Yeah, counsel is another name for barrister. So counsel, COUNSEL, sounds similar to council, local council, local government, spelt differently. But counsel is a barrister, and they are a lawyer. Yes.
Okay. And the last question is, do you address the justices, Your Honour, in the higher
Yes.
court? Yes.
Yes.
Yeah. All right, well, let's move forward then onto this slide that's common words used in court. Do you want to go through those, Helen?
Yep. So I've talked about mention a little bit, and it's like an administrative appearance in court. It's a short time in court. It might be 5 minutes or 10 minutes or 15 minutes. For example, the magistrate might ask, what's happening in this case? And we might be there to say, I've received a brief of evidence from the police, or I haven't received a brief of evidence from the police yet. Or it might be checking. The magistrate might give you some orders and might say, okay, I would like you to file some documents by a certain date. So you might be given some orders to do things by a certain date, or the magistrate is really checking, or the judge is checking what stage this is up to. It might be checking, are we ready for the trial? You might have a mention just before the trial is about to start, and checking that everything's ready to start, that we're ready to go. So the mention is in time. It's a short appearance in court, but it's checking what stage things are up to. That's really what it's about. The case will not be finalised at a mention. The case is not finished at a mention.
Can I just ask, Helen, as one question, is a mention always the first appearance in court?
Maybe a bail application is the first appearance in court, but then there'll be a mention for the magistrate to order the police to serve a brief of evidence. So either a bail application is first, but at the same time, whether you get refused bail or granted bail, the magistrate will give some orders. Then you'll come back to court, for example, in 8 weeks' time for mention, to see if the police have done what they've been told to do, and that is serve the brief. So the mention might be the second, it might be the third appearance as well.
Thank you.
Hearing or trial. A hearing can mean multiple things. For example, a local court defended hearing. Somebody has pled not guilty. Their case is staying in the local court. The police prosecutors are going to appear to prosecute the matter. You are appearing before a magistrate, and the magistrate decides guilty or not guilty. That's a hearing. A local court defended hearing, because you've pled not guilty, you're defending the charges. A hearing can also be a sentence hearing. you might have pled guilty and the magistrate is hearing the evidence, or you might be in the district court for a sentence hearing and the judge is hearing the evidence, reading the documents, listening to submissions. That's also a hearing. A bail hearing, a bail application or a release application can also be a hearing. It's listening to something. It's listening to evidence, listening to submissions, reading submissions, making a decision. A trial is in the district court. Some people call hearings, some people call trials hearing. It's not wrong, but I like to distinguish. A trial is in the district court or the Supreme Court with a judge or a justice if it's Supreme Court, and you can have a jury, 12 citizens, random citizens deciding guilty or not guilty. So a trial is in the district or Supreme Court. Hearing can be a defended hearing, not guilty, or a sentence hearing or a bail hearing. Committal hearing is in the local court. These are less common, but they do happen. And it's an application has been made to cross-examine some witnesses, not every witness, but some or one witness. And you might be trying to test the memory of a witness or test some evidence. How strong is that evidence? For example, there might be an issue about identification of the person that robbed the bank, and you might be seeing if you can challenge some of that identification evidence. Maybe your client isn't the person that's described, or there might be some confusion. So that is heard by a magistrate. The magistrate makes sure that the rules are followed and everything happens fairly. It's in the local court, but after that happens, you will go to the district court. In the local court, the magistrate can no longer decide to stop the prosecution of the case. The magistrate can no longer decide to what's called discharge or discontinue those proceedings. The magistrate no longer has that power. So a committal hearing is perhaps a bit strategic. Do we want to test some evidence before we go to the higher court? It's a committal hearing. So as an interpreter, you may have to, at some stage, interpret during the committal hearing. The accused will be in court and their lawyer will cross-examine some witness or witnesses. Call over is, it might be in front of the registrar, and the registrar might be have a list of matters where a subpoena has been issued, and we'll mention those in a minute. So you might be in the registrar's call over, or you might be in a call over in the district court or Supreme Court, a bit like a mention. Telling the judge or the justice or the registrar, are we ready yet? What's happening with the case? Have all the documents been served? It's really checking, are we ready yet? So call over, it's checking that certain things have been done, and maybe some orders will be made to file this document, serve a report by a certain date. So it's a call over, and there might be some things to do after that, some orders made after that.
Helen, can I just ask a question? Someone's just typed in, does the accused have to appear at a call over?
No, they don't. Some accused want to. Some judges want the accused there, and other times, if the judge doesn't require them, then no, they don't have to be. And return of subpoena, no, the accused is not required either at the registrar's return of subpoena or call over for return of subpoena. The accused is not required. Depends on the matter, depends maybe on what issue it is. Very often, no, the accused is not required. An interim hearing. Oh, sorry, any other question?
There's a couple of questions, but I think keep going because I'll either read them at the end or we're going to cover them on other slides.
No problem. Interim hearing or an interim order is, for example, the best example I can give is an AVO, which we will discuss later, but an apprehended violence order, for example. The order is not final yet. It's temporarily in place, but in the meanwhile, or in the interim, there are some temporary orders in place to prevent somebody from doing something. And that's in place until a decision can be made about whether there will be final orders. So there's still some rules, some orders in place, cannot do this, cannot do that. There might be, sometimes there'll be an interim hearing. It may not just be AVOs, there might be, in criminal law, it's usually, that's usually the issue to do with AVOs, but in some other types of law, some civil law, there might be some, or even family law as well, there might be some interim, some orders in place for the moment prior to the final hearing, final decisions taking place. So, but there's still, if you break the interim orders, if you break these, if you breach these, you can be charged. It can be a crime. So they're very important that the rules are followed. Adjournment is an application by either side to for another court date, to an adjournment, not ready to finish the matter yet, or not, something hasn't been done yet, something still needs to be done. For example, police say we need more time to serve more documents on the defence. So they will seek an adjournment. They might want 1 week, they might want 4 weeks, they might want 8 weeks. They want an adjournment. They want more time. They're asking the court to give them more time to do something, come back to court on another date, and then we have to see whether that's been done. So it's an application to adjourn. It's asking for more time to do something. Stay or stay of proceedings. This is very hard to achieve. It can be temporary or permanent, and it's like stopping it. Staying is like stopping it. Might be temporary. For example, somebody's health might be temporarily declining and they need to go and have an operation, some medical treatment, or the health might be permanently declining and the person is not getting any better. So you may want to stay the proceedings permanently, permanent stay, stop the proceedings. Or it might be a person has run out of money and they want to temporarily stop the proceedings until they've had time to save some money or apply for legal aid. And so a temporary stay of the proceedings until something, they've had time to save the money to do something. It is very hard to get, for example, a permanent stay. There have to be extremely good reasons to stop the criminal proceedings going ahead permanently. And I should say that the charge isn't dropped, it's just the trial's not going to go ahead. So the DPP haven't actually withdrawn the charge. It's an application to the court to stop the proceedings going ahead. And that's what the word stay in that circumstance means, stop it. It's very hard to get though, very hard to achieve. Injunction is an order to stop somebody doing something or stop a corporation doing something. There might be an injunction on media publishing, and that might be a non-publication order. There might be, in civil cases, there might be an injunction on a building being demolished. It's stop something happen. There's an order it's, you know, the best examples I can think of is the media, an injunction on the media publishing the name of somebody in the case. It's about getting a fair trial. You may want the name not to be published, or the fact that an application has been made not to be published, so that the jury do not read about it or hear about it in the media until after the case has finished. So it's an order, a court order to do something, or usually to stop doing something. Ex parte is when something happens without a person being present. So a judgment might happen ex parte. Somebody has failed to turn up to court, and the judgment is made ex parte without that person present, without that person in court. You cannot get a jail sentence ex parte because you need to be present in case you have to be detained and taken into jail. But you can get other types of sentences made in your absence. You're not present. You're not there. You're absent. So some sentences can be made ex parte. Judgments can be made ex parte. Not present. Person is absent. Jurisdiction can be a couple of words. Where something happened, the place. New South Wales, the state of New South Wales, is a jurisdiction. New South Wales law or Commonwealth law applies in New South Wales. The state itself is a jurisdiction. The other way that it can be used, this word, is does the district court have jurisdiction? Do they have the power to deal with this particular matter? Or does the Supreme Court have jurisdiction to deal with this particular matter? Or does Queensland, the state of Queensland, have jurisdiction to deal with a crime that happened in New South Wales? Does New South Wales have jurisdiction to deal with a crime that happened in Queensland? And so people get extradited and brought to the different states, sent to the other state, so that their case can be dealt with in the state that it happened. Because, for example, New South Wales will not have jurisdiction to prosecute somebody for something that allegedly happened in Queensland. Queensland needs to do that. So if the person is in New South Wales, Queensland will have to apply to extradite the person to Queensland so that their case can be dealt with in Queensland. So the jurisdiction can have a couple of meanings there, a couple of applications. The court having the power, or the location itself is a jurisdiction.
Thanks, Helen. Now, there are a few questions. Do you want me to run through those?
Yes, yep, I'm happy to go through those.
Do you need a drink of water or something? You've been talking for an hour. You're right to keep
I'm
going?
okay. Yep, I'm okay.
Okay.
Thank you.
If there's an AVO plus criminal charges, sometimes the AVO gets listed as mention with the hearing for the
Yes,
charges. But in
yes.
that case, it does not get finalised on the date of the hearing. Is that correct?
Okay, while the charges are not yet finalised, yes, so often with a criminal charge like an assault, an act of violence usually, or sexual assault, which is also potentially an act of violence, there will often be an AVO tagging along, going along. Police prosecute the AVO, not the DPP, so I will mention my criminal charge, which the DPP lawyer is involved in, and I'll also mention the AVO, which is connected or associated with or connected to that criminal charge. If a person pleads guilty or is found guilty, the AVO will be automatic. It will be made. If a person is pleading not guilty, the person can still consent to the AVO without making confession or admission. It's called consent without admissions. They can still make an agreement to have the AVO orders put in place without admitting the crime. And then the orders will be put in place and the magistrate will explain to the person what those orders are. Or I might not, as defence lawyer, I might not have instructions from my client about the AVO yet. And so I need to get instructions. And so I ask for the AVO to be adjourned for mention the same date as the criminal charge is coming back to court. The AVO will not go up to the district court or Supreme Court. The AVO does not travel to the higher court. The AVO stays in the local court. Some people who are, for example, pleading not guilty to the criminal charge will ask for the AVO to be adjourned until after the criminal charges have been finalised, because if they win the criminal charge, they might ask the police to withdraw the AVO, not prosecute it. The thing to remember with AVO, it's actually civil and it's a different test. It's balance of probabilities. It's not criminal. It's not beyond a reasonable doubt. But if you breach or break the rule of an AVO, then you can be charged with a crime. It is a crime to break the orders of the AVO. But yes, you will often hear the AVO is adjourned and mentioned at a later date. It will start off being mentioned at the same time as the criminal charge, but it's always mentioned by the police prosecutor, not the DPP lawyer. Hopefully that makes sense. So sometimes you'll have both the police prosecutor and the DPP lawyer speak about the same matter. One will be talking about AVO, one will be talking about the criminal charge.
Okay, thank you. Now there is a question here, the difference between bail and bond. Are we going to talk about that a bit later on?
Yeah, bond. If bond, that might be the use of the word bond may have different. I think in the US you get bonds meaning the bail. So we don't use bond for bail here.
Right.
So bail is conditional liberty, and you may need money. You may need to deposit money to get the bail, or it may or may not be a condition. A bond is also an old word for some sentences in New South Wales. So the word bond has a couple of meanings. So we will be talking about sentences later, but if you're talking about bond as in bail money, we don't use the word bond for bail money, but they do in the US. Okay. But bond in terms of a sentence, we no longer have they're not called good behaviour bond anymore, but we'll be talking about sentences later today.
And then someone's asked you to distinguish when to use person of interest, offender, suspect, and accused.
Okay. Person of interest is a word used, POI is a word used by police when they are investigating something. So the person of interest is the person that they haven't charged yet. They're still investigating. They haven't yet arrested or charged the person yet. POI, or person of interest, may also be used on the documentation in the AVO documentation, person of interest, POI. Accused is the person has been charged and they're accused of the crime, but they have not been found guilty. They have not pled guilty. They're still accused. Offender is when a person pleads guilty or they are found guilty and they are coming up for sentence, or during the sentence proceedings, they are called the offender. So they're no longer accused. They are now found guilty or pled guilty, and they are now the offender. So on a sentence, you will hear them called the offender, and that will be written into the agreed facts. If they're pleading guilty and they agree to some facts, it'll be the offender committed the robbery on this date. The offender was born on this date. The offender, because they have admitted their guilt, they're guilty. Whereas in trial, person has pled not guilty, they are the accused or the defendant. The accused or the defendant. Did
Okay.
I get all of those?
Oh, one
Accused,
of them was suspect.
a suspect, sorry. You are a suspect when police are questioning you. You are suspected. You're not yet charged. And not all suspects are charged. So you're under investigation, and the electronically recorded interview of a suspected person. You're a suspect. You haven't yet been charged. Police think you did it. Police are investigating. They're questioning you. You're a suspect. You're under suspicion. You're a suspect. After you are charged, you are the accused. After you plead guilty or you're found guilty, you're the offender.
Great, thank you. Um, Someone's written here, committal and interim hearings both seem to test readiness for court. What is the difference between the two? Can both occur in one matter, and in what order would they take place?
No, they're very different. Interim hearing, I explained that is it's not readiness for court. It's a interim hearing will be about, for example, you might have an application for orders to protect somebody, orders, or even an interim hearing about forensic procedure prior to the case finishing. There's an interim order to, for example, forensic analysis. It's in the meantime. The case hasn't finished yet. You're not testing if anything's ready yet. It's not. Interim hearings are not about testing if the case is ready. Committal hearing is also not about testing if the case is ready. A mention or a call over is to check what's happening. Are we ready? Has everything been done yet? That's a call over or a mention. A committal hearing is maybe cross-examining a witness or two. So it's not testing if it's ready. You might test the strength of the case, but it's a committal hearing is not about testing if it's ready. It's a specific purpose to cross-examine, make an application and cross-examine some witnesses.
Okay.
I hope I've explained that. Yeah.
Yes. Someone's just saying that sometimes a judge can say the matter is adjourned, but it can mean the matter is temporarily paused for a few hours or days, or it can mean it's dismissed. Is that correct?
No, if it's adjourned, it's temporarily paused. It could be adjourned till 2 p.m. today, could be adjourned till next week, could be adjourned for 6 weeks. Adjournment, it's still going. The case is still going. If it's dismissed, or if the case is dismissed, then it stops. If somebody, or likewise, if the magistrate dismisses the charges, charges withdrawn by the prosecution or police, withdrawn and dismissed, case is finished. But adjournment is not stopping the case permanently. It's not. It's just a temporary thing until the next time.
Okay. Well, we might move forward now onto words used in criminal law. If you want to work your way through these, Helen.
Yep, definitely. So a summary offence is dealt with in the local court. There's a wide variety of these, and there is a Summary Offences Act. Many of these you get a fine for. It might be offensive language, offensive behaviour. You often might just be a fine. Some of them will have jail, but it might be goods in custody, having stolen property in your possession, that's goods in custody, something like that. they're less serious. I don't want to say that they're not serious, because if somebody is facing prison, then it's serious. It is serious, and it's serious to that person. But they're less serious than the next set of offences being indictable. Indictable offences carry 2 years imprisonment or more. So it can be ranging from common assault, which carries 2 years imprisonment, right up to murder, carrying life imprisonment. So very broad range of offences. A serious indictable offence, by definition, carries a maximum penalty of 5 years or more. That could be stealing, which is larceny. It could be stealing. It could be an assault occasioning actual bodily harm, which is some injury. It could be inflicting grievous bodily harm, but it's 5 years maximum penalty or more. That's the maximum available. It doesn't mean the person will receive the maximum, but that's the legislation gives that maximum penalty. So summary offence, indictable offence. Some indictable offences, the prosecution will choose to go up to the higher court. These will not all stay in the local court. They may have to go up to the higher court. In indictment, if you're going up to the district court or Supreme Court, and if you're interpreting in the district court or Supreme Court for a trial, you will be asked to interpret the indictment. So what is the indictment? The indictment is a piece of paper with the charge, the criminal charge, written on it. And when the person is arraigned, okay, which is the third word there, arraignment, when at arraignment, which happens in district court or Supreme Court, when the person pleads not guilty, the charge is read out. The charge is printed on the piece of paper, which is called the indictment. And the judge is given a blue piece of paper, and that is the indictment. As the interpreter, feel free to ask the court or ask the lawyer for a copy of the indictment so that you can see it, the words that you have to interpret. It is read out by the judge or the judge's associate. They'll read out the charge on indictment, and you as interpreter will have to interpret that Mr. Smith, on the 11th day of October 1985, did assault Miss Jones in the state of New South Wales. How do you plead, guilty or not guilty? And Mr. Jones says, or Mr. Smith says, not guilty. Okay, you as interpreter have to interpret that. You have to interpret what charge has been read out. And sometimes there's many charges on the piece of paper. So please ask for that. As defence lawyer, I give the interpreter in court, I give the interpreter a copy of it so that you can see it. Please ask the lawyer or the court for a copy of the indictment so that you can easily follow what you are having to interpret. I think that's important, and it's not wrong to ask. I think you should be able to have a copy of that. So when somebody is indicted, that means they're charged with it, they're indicted, or the indictment has been presented, that piece of paper has been presented, and the prosecution lawyers are prosecuting them for that charge. They have been indicted on that charge. So those words, you'll hear them, you'll see those words written, you'll hear the lawyer should hear the lawyer talk to their client about arraignment and what is going to happen at arraignment. That's what's going to happen at arraignment. The charge is read out, the indictment is read out, and the person enters their plea, guilty or not guilty. And if they plead not guilty, then they're given a trial date. Or they will also, if you're interpreting during a trial, the person will have to stand up and plead not guilty in front of the jury. So that indictment is read out in front of the 12 people on the jury. You will have to interpret that, and the person will plead not guilty, and then the trial starts. So it's a very important part of the trial process, having the jury listening to this person say, I'm not guilty of those charges. Acquit is when you find somebody not guilty. The jury finds the person not guilty, they acquit the person. A magistrate can also acquit or find the person not guilty. Acquit is not guilty, finding the person not guilty. So if they're acquitted, they're found not guilty. Acquit is a verb, to acquit somebody, find them not guilty. Penalty is you've pled guilty or you've been found guilty and now you're given a penalty. It could be a fine. It could be a good, what used to be a good behaviour bond. We'll get to sentences in a minute. It could be jail. And we'll, as I said, we'll get to the various sentences soon, but that's the penalty. So that's as a result of being found guilty or pleading guilty. You're sentenced and you're given a penalty. Remand. When somebody is arrested and their bail refused and they're in custody, meaning they're in jail, they are on remand. They're not sentenced yet. They're waiting for their case to come to court. They're waiting for their trial to start, or they're waiting for their sentence to be finished. They might be pleading guilty, but they haven't been sentenced yet. They are on remand. And so when somebody's on remand, they're in jail, their bail refused, they often don't have the same access to courses, and some don't have access to work or jobs in prison when they're on remand. They're unclassified by corrective services. So they don't have as many opportunities sometimes when they're on remand. So they're unsentenced and they're unclassified. They're still on remand. Custody, two possible. You're in police custody when you are arrested. So you're in custody, you're not free to go, you're in police custody. You're at the police station in custody of police. Even when you're in the police car going to the police station under arrest, you're in police custody. If somebody's in the cell at the police station, they're in police custody. They're not free to go. Also, you are in custody when you're in jail. You're in custody, but this time it's corrective services who are under obligation to look after you, to take care of you, to feed you, to house you. Police are no longer in charge of the person, corrective services are. So you can be in custody under police control, or you can be in custody under corrective services control. Family law has a totally different meaning of custody of children, different things. So criminal law, they're the two meanings for custody in criminal law. Sentence, so this can be a noun and a verb. Okay, so as a noun, what sentence does somebody get? What penalty does somebody get? Do they get a fine? Do they get jail? Do they get an order with conditions to, for example, to be of good behaviour, like an intensive corrections order? We'll get to sentences in a minute. Or the verb, to sentence somebody. To sentence. The magistrate or the judge sentences somebody. They impose a penalty. So verb or a noun. Sentence or to sentence. Parole and non-parole. So a sentence, a jail sentence, a prison sentence is made up of two components, non-parole period and parole period. The sentence is structured The standard prison sentence is structured so that 75% or 3/4 of the sentence is the non-parole period, which is the time you spend in custody, in prison. It is the minimum time. It's not like America where you get time off for good behaviour. No, it doesn't reduce. So the non-parole period is the minimum time in jail. You must do that time before you are eligible for parole. The sentence will be 3/4 non-parole and 3/4 non-parole, or 75% non-parole is time in jail, and 25% or 1/4 on parole in the community under supervision by community corrections, who used to be called parole. Now, if at sentence there's a finding of special circumstances because maybe they're young, maybe they're old, maybe they're sick, maybe they have a mental illness, all of the above, something different, you can adjust that 75% and 25% ratio. You can adjust it so the magistrate or the judge can say, well, I'm going to give you a bit less time in jail because you've got all these other issues, and I'll give you more time under supervision in the community on parole. When a person's on parole, they are still serving their sentence and they still have to be of good behaviour. If they get into any more trouble or they fail to go to appointments with their parole officer, then they're in trouble. They will be breached. They can face going back to jail because the parole period is still a part of the sentence. So when we get to head sentence is the total. It is the non-parole plus the parole. Head sentence is the total sentence. It is that 75% non-parole period plus the 25% parole period. It is the total sentence. That's called the head sentence. So you'll hear lawyers and judges and clients sometimes will ask, well, what do you think my head sentence will be? That's what they're talking about. That's the total sentence. That's so a sentence might be 4 years. The total sentence or the head sentence might be 4 years imprisonment, and the non-parole period might be 3 years imprisonment. The non-parole, 3 years with 1 year on parole. Total 4 years. So I hope I've explained that. And you'll hear non-parole period and head sentence or total sentence. You'll hear that when the judge or the magistrate is delivering a sentence. Hung jury is when a jury, 12 people, cannot all agree on a verdict. Some of them think the person's not guilty and some of them think they're guilty. Hung jury is they cannot all agree, and they also cannot reach a majority verdict. In New South Wales, majority verdict, if it's going to be one, has to be 11 to 1 or 1 to 11. 11 people saying guilty, one person says not guilty, or 11 people says not guilty and one person says guilty. 11 to 1 is 11 to 1 is a majority verdict, but 10 people versus 2, 9 people versus 3, 7 people versus 5, that's hung jury. They can't reach a majority verdict. They can't reach unanimous. It's hung jury. And what happens is, so it's a deadlock, no agreement. What happens is the trial will have to start again. Basically, the trial has to start again. Usually the prosecution will prosecute again, and it has to start again. New judge, or sometimes new judge, new jury. 12 people on the jury get sent home, get sent away, and new people have to be chosen, and the trial starts again. That's hung jury. Okay.
Thanks, Helen. We'll move on to the next slide, which is more words used in criminal law. there were a couple of questions, but I think you answered them as you went along, so we'll keep going.
Yep, no problem. So cover this a little bit. The police charge somebody. It can be a verb or it can be a noun. The police charge somebody, so that act of charging somebody, a verb, or a charge. Somebody is on a charge. It's a noun as well. So armed robbery is a charge. Sexual assault is a charge. So it's a verb or a noun. You're charged by police and then you're facing a charge. You're facing several charges. Form 1 offences, you'll hear this in sentencing or negotiations if you're involved in conferences where there are negotiations about Form 1 offences. Person pleads guilty, they admit their guilt, they've done it, but the prosecution have agreed to place that charge on a Form 1 document when the person gets sentenced for a different charge that they are pleading guilty to. Best way to explain is with an example. So example, break and enter. Break and enter in somebody's house. I'm pleading guilty to break, enter and steal. And in that break and enter, I stole the wallet and I went and used the credit card at a shop. I spent some money on the credit card and I'm charged with spending the money on the credit card because that was a crime as well. Obtain money by deception. So my lawyer has negotiated and the prosecution have now agreed to, if I plead guilty to the break, enter and steal, I plead guilty to that, they will place that other charge, that using the credit card, on a Form 1. So the consequence of that is I sign a piece of paper, I sign a document asking the judge, please take that other charge into account when you sentence me for the break and enter, which I'm pleading guilty to. And as a result, I do not get a separate penalty. Judge knows that I'm guilty. I've admitted I'm guilty of it, but I don't get a separate sentence for that other charge for using the credit card. So in theory, hopefully I get less time in jail than if I was getting a separate sentence for the break and enter and a separate sentence for using the credit card, because the credit card has its own maximum penalty, has its own possible penalty. So hopefully the overall result will be better for me than if I had separate sentences for both those charges. So that's a Form 1, and you'll hear that a lot in the local court and also the district court. A backup charge is the best example. I'll illustrate this with an example. You've got supply prohibited drug and you've got possess prohibited drug. So police have charged me with both. They've charged me with supplying 10 grams of cocaine and they've charged me with possessing 10 grams of cocaine. And I say to police, and police they had to send the cocaine to the laboratory, or the substance. They send the white powder to the laboratory, and the laboratory says, oh, it's not 10 grams. No, it's not 10 grams. It's 3 grams. We've weighed it. It's actually 3 grams. So my lawyer tells the police or the prosecution, well, actually, if you drop she wasn't supplying. Yes, she admits she was in possession. You can only prove 3 grams. So, and she was using that. That's her personal use. So she's a cocaine user. She wasn't supplying it. Yes, she's guilty of possessing it, but it's for her personal use. So, okay, police agree, or prosecution agrees, they will withdraw the supply charge and they'll accept my plea of guilty and I get sentenced for possession. So the possession charge was a backup to the supply charge. I won't end up being sentenced for both. They will withdraw the supply charge and I'm going to plead guilty and get sentenced for the possession charge. So that's a very common example of a backup charge. Or it might be a more serious assault, inflicting grievous bodily harm, intentionally inflicting grievous bodily harm, with a backup of recklessly inflict grievous bodily harm. The state of mind's different. One is more serious than the other. Reckless is less serious than intentional, and I might say to the prosecution, can you withdraw the more serious charge and I'll plead guilty to the less serious charge, and they agree. So they're not two separate offences. They're not two separate incidents, not two separate victims. It's one charge, but I will agree to the less serious charge, and they'll withdraw the more serious. The less serious charge is the backup to the more serious charge. That's hopefully those examples illustrate that. Sentence assessment report is a report which is written by what used to be the probation officer, parole officer, is now called community corrections officer. It's a report, and I don't like these. They're never usually very good. They're never usually very positive. The report writer sends it straight to the court. So as a defence lawyer, I may not see that until the day of court or the day before court. They'll speak to my client. They'll talk to them about the offence that they've pled guilty to, their attitude. And if my client says it wasn't my fault, my lawyer told me to plead guilty, I'm not really guilty, my friends made me do it, then it's going to be a very terrible report, because the report writer will say that my client takes no responsibility, has blamed everybody else for it, and is not really sorry. So it will be a terrible report, and the magistrate or the judge will read it, and I can't fix that problem. So anyway, that's a sentence assessment report. It's written by community correctional parole officer, goes straight to court. What they may have is if somebody wants home detention, you need one of those reports, because they have to assess the person. Are they suitable for home detention? Also, if you want community service, that has to be, you have to ask for one of these reports, because that person, there's an assessment, are they suitable for this type of punishment? So those reports are needed in those occasions. Agreed facts are when you're pleading guilty and you're agreeing that you're guilty, you, instead of the judge getting 200 folders of material to read, the lawyers will summarise it into a few pages, and the client has to sign it, agreeing that those are the facts of what I did wrong. Those are the facts of the case. So it's a summary of the evidence, and client has to sign it, and the prosecution sign it, and the judge reads that document, the agreed facts, and that's what they sentence you on. So that's agreed facts, and that's handed up or tendered in court. Agreed facts. Burden of proof. This is, and the next two, beyond reasonable doubt and balance of probabilities. So the burden of proof, the prosecution has the burden of proof. Who must prove something? The burden or the responsibility is on the prosecution. In criminal cases, it's beyond reasonable doubt. It's meant to be a very high standard. There shouldn't be any doubt that the person accused of doing something has done what they're accused of doing. If there is doubt, for example, or there's some other reasonable, in the jury's mind, reasonable explanation, some other reasonable explanation, or some other reasonable possibility, maybe there's a reasonable possibility that somebody else did the crime, or maybe there's a reasonable possibility that that the person did not break into the house. Maybe there's a reasonable possibility that the door was wide open, that they didn't break into the house. If the prosecution has not proven the ingredients of the offence or elements of the offence beyond a reasonable doubt, then the person should be found not guilty. What is reasonable? That's a matter for the jury. And we don't know what different people would think different things are reasonable or unreasonable, but it's a matter for the jury. But if there is a reasonable doubt, then they should acquit or find the person not guilty. In AVO, apprehended domestic violence order, or apprehended personal violence orders, the test is balance of probabilities. And civil cases, so somebody suing somebody for breach of contract, balance of probabilities, more probable than not. It's less difficult to prove balance of probabilities. It's easier to prove on the balance of probabilities than it is to prove beyond a reasonable doubt. So, yes, civil matters, including AVO, the test, the burden of proof is balance of probabilities. Weighing up the evidence, balance of probabilities. Again, matter for the judge if it's judge alone, matter for the jury if it's with a jury, whether the burden of proof has been achieved. Objective seriousness, you will hear this in sentence matters all the time. The magistrate or the judge has to determine the level of objective seriousness. How serious is this offence compared to other offences of this type? So an assault, a common assault, there's all different facts, all different circumstances. Many people are charged with this. Is this example really much more serious than that example? Sometimes, assault occasioning actual bodily harm. Somebody might have a red mark, somebody might have a bruise, someone might have a black eye. How serious are we talking? How serious is the injury? How serious is the example of the accused or of the offender's behaviour? How bad is it? How bad is it compared to other cases? Stealing, how much money was involved in this? How, the objective seriousness, what are we talking about? What was the value of the property that was stolen? Did the person get it back? Or is it still missing? Those sorts of things, how serious compared to other examples. So the magistrate or the judge has to sort of weigh things up, have a look at other cases that they've experienced, that they have dealt with, and make an assessment or a judgment about how serious is this compared to others of its type. It's a bit can be artificial, but they've got to make that value judgment. Special circumstances, you will hear this in sentencing, and I explained this before when I was talking about the structure of the sentence: 75% non-parole period, 25% parole. If you get a finding of special circumstances, for example, very young, very old, very sick, maybe the first time in jail, may not have a good grasp of English language, and you're in jail with most people speaking English, mentally unwell, intellectually impaired, variety of reasons, maybe a combination of reasons, may have a very bad drug habit and needs rehabilitation for that. Special circumstances will allow the magistrate or the judge to adjust or change that ratio. So instead of 75% non-parole period and 25% on parole, they might make it 50% non-parole period, 50% on parole, or 66% non-parole period, 33% on parole. So they adjust that ratio. So in effect, in practice, you spend less time in jail doing non-parole, more time in the community on parole. So it
Hmm.
shortens the time that you're in custody serving the non-parole period. It adjusts the ratio. So you will hear that. You will hear the defence asking for that, a finding of special circumstances. That's what they're asking for, and that's why they're asking, because they're trying to reduce the time that their client is spending in custody. The judge or magistrate can refuse to make a finding of special circumstances, and if they refuse, then the sentence will stay 75% non-parole, 25% on parole. And that is under legislation, sentencing legislation, that's the structure of the sentence. It's a mistake if the judge gives somebody 90% non-parole and 10% parole. That would be a mistake, and that
Right.
somebody could appeal that. Yeah.
Um,
So
someone someone has asked a question, Helen. Is a SAR the same as a pre-sentencing report?
yes. The
Okay.
pre-sentence report is the old name, and now it's called a sentence assessment report.
Okay. I'm just conscious that we've got 10 minutes till 12 o'clock. We've probably got a good, I don't know, 30 minutes left. So if people need to go at 12, just be aware that we have recording it. So it will go up on our YouTube channel next week. So if you do have to leave, then you can watch the recording. So Helen, do you want to take us through these legal document words?
Yes. So an affidavit is a sworn or affirmed legal document. It is a form of giving evidence on paper, and I make affidavits as a solicitor. I present it to the court. Instead of giving oral evidence, it's written evidence. It has to be true, and I have to swear or affirm that it is true. Or a client might make an affidavit, or a police officer, anybody can make an affidavit, a witness can make an affidavit. It's in writing. It is facts explaining something that's happened, or it can be for a variety of reasons. I might use this in a sentence proceeding. I might get mum or dad of a client to do an affidavit, um, or a letter. It's the difference between a letter and an affidavit. A letter is not sworn, it's not affirmed, it's not promising to tell the truth. But an affidavit is a legal document, and if anything is false in it, a person can be prosecuted for it. It's very, very similar to the statutory declaration. With statutory declaration, we make these in everyday life, whereas affidavit, it's more for court. Statutory declaration, you'll be making a statutory declaration. Back in the day, pre-COVID, when we used to fly internationally into Australia, and you're declaring that, you're saying this is the truth. I'm not carrying any plants or food or anything. You're making a statutory declaration. It's a legal document. Or when you go to the post office and you get a passport application form, there's a statutory declaration on that. You're declaring that what you are saying is the truth. You're filling out a form and you're making a declaration. And any false declaration, any false words on that can be prosecuted. So they're very similar, but I will not use a statutory declaration in my court proceedings. I'll use an affidavit, and so I'll use an affidavit. But essentially, they're a sworn or an affirmed statement saying the contents of this. What I'm saying is true. I'm not lying, and it has to be witnessed, okay, by justice of the peace or a solicitor. And a deponent is the person that is making the affidavit. So if I am swearing or affirming the affidavit, I am the deponent. When a notice of motion is an application by a lawyer seeking certain orders of the court, and I always must provide an affidavit with the notice of motion justifying or trying to argue why I want those orders made. So a notice of motion is a one-page document with orders. For example, asking the court to vacate or cancel or change the trial date. And I'll have to give my reasons why I'm asking for the trial date to be cancelled, changed, vacated. Example, police have just served me with 3 folders of new material. I'm not ready. I need to get an expert report. Something's happened. Okay, so I have to justify my reasons and go to court and argue it. So I need a notice of motion, which is just a piece of paper that sets out the orders that I'm asking for, asking the court to make. But I must justify it with an affidavit. A subpoena is a court order, it's a document, and I might issue a subpoena on police or a witness to come and give evidence. And I take it to the court registry, the court issues it, the court stamps it and issues it. And if somebody fails to obey that subpoena, like fails to attend court or fails to produce the documents, then there can be a warrant for the person's arrest. So it becomes a court order to do this. Produce these documents or attend court. So if you get a subpoena, you must attend court. An oath or an affirmation is religious, promise to tell the truth, and the affirmation is a non-religious promise to tell the truth. They're equal weight in court, equal weight on a document. So there's oath or affirmation on a statutory declaration and in an affidavit. Both are equal weight. Somebody gives oath or affirmation when they give evidence. You, as interpreter, make an oath or affirmation when you attend court to interpret for the person that's giving evidence, or to interpret for the accused in court. You will be on oath or affirmation. You'll be sworn in or affirmed.
All right, there wasn't any questions there. Move on, Helen, to talking about offences. The first ones we're looking at is against the person, if you want to work through these words.
So offences against the person, typical ones, common assault, that does not have to be physical, it can be verbal. So I might swear at somebody, I might make a verbal threat at somebody. And I might, if I'm intimidating or frightening, putting somebody in fear, or I might say, I'm going to hit you, but I don't actually hit the person. But that would be an assault. I'm going to hit you because I've made a threat. And I might have frightened somebody. But a common assault can also be physical, can be verbal and physical, or verbal or physical. I might push somebody, I might spit on somebody, I might hit somebody, but I don't make an injury. I don't cause an injury. That's common assault. Maximum penalty, 2 years in prison. It's serious, but it's not as serious at law as actual bodily harm or assault occasioning actual bodily harm. Actual bodily harm might be a bruise, might be a bite mark, might be a scratch, a red mark after being hit. Actual bodily harm, varying levels of actual bodily harm. A bruise might take longer to heal than the red mark from being hit on the face. Somebody might leave a red mark, but the red mark will disappear. The bruise might take a few days. Actual bodily harm, those are examples. 5-year maximum penalty, so it's more serious. Grievous bodily harm is much more serious. Much higher maximum penalty, might be caused by a stab wound, might be caused by a knock to the head which causes internal bleeding. That's an example of grievous bodily harm. It can be intentional or it can be reckless, and depending on if it's reckless, not intentional, be a less maximum penalty than if it's intentional. But intending to cause grievous bodily harm can be a 25-year maximum penalty. Very serious allegation. Some people do recover from grievous bodily harm. People can recover, but some people don't. It can also be, so the degree of grievous bodily harm can also be very different. And that's when we go back to objective seriousness. What was the actual injury? What was the intention? What was the actual injury? Different levels of severity can result in a different penalty. Affray, this can be committed by two people not in public. It's a very strange offence, or it can be like a fight in public, causing people to fear. But maybe nobody's around to be afraid, but the potential is there if somebody could have been around, could have been afraid of these two people fighting. It might be with or without weapons, doesn't have to be weapons. And involving two people, it can be quite a strange offence, a fray. So it can be a big group of people, can be just two people, a fray, and it can carry 10-year maximum penalty. So it can be quite serious, but I would think it'd have to be very serious to get anywhere near the maximum penalty. A brawl, there's no actual charge called brawl, but in common language, it's a fight. With or without weapons, it's a fight with two or more people, brawl. So,
Okay.
yeah.
Thank you. Well, the next slide is coming up. It's about sexual offences.
Okay, so you, as an interpreter, there'll be many people go to trial for this, and this will come up all the time. Sometimes it can be embarrassing with all the words, the language that comes with this, but it's really important. As a lawyer, I have to not be embarrassed. I have to just say the words, and as an interpreter as well, we have to not judge, and we have to just use the language as it is, even though we may not feel comfortable and it may feel embarrassing. So please don't be embarrassed when I have to explain these words. They do come up in law all the time, at the police station and in court. So sexual assault is a much more broad definition than rape. Traditionally, historically in the past, rape was charged a man or male against a female victim, a male perpetrator or male accused. And it would be really, and I'm sorry I have to use the words to explain it, but as an interpreter, I'm sure you'll be used to this, and as a lawyer, I have to be. Rape used to just cover really penis and vagina, male, female. Sexual assault covers male and female victims. It recognises that male are also victims of sexual assault, and sexual assault, not just the female body part, not just vagina, can also be anus, so male or female body parts, and it can also be penetration, using finger into a body part is sexual assault. Inserting penis into a mouth is sexual assault. Okay, so there's different types of sexual assault, different types of activities, which include sexual assault, and it's penetration of a thing or a body part into somebody else's body part. Okay, mouth, vagina, anus, and victims can be male or female, and perpetrators can be male or female. Historically, that wasn't really recognised. So the law has become much more broad to cover more victims and more actions. So sexual assault. So people will not be using the word, the police will not be using the word rape, they'll be using sexual assault. As interpreters, we have to use, so to understand why that is, that the law is much broader now, the sexual assault. Sexual touching, the law keeps changing, and last year the language changed from indecent assault to sexual touching, which I actually think is more accurate. Sexual touching is more accurate than indecent assault. Like, what is that? Like, who knows? Like, it's confusing. So it might be touching, but not penetrating. Okay, so that's the difference. Not so touching somebody's genitals, for example, touching somebody on the bottom, the backside, touching somebody's breasts, touching somebody's penis, vagina, can be under clothing or on clothing. Can be on the, somebody can be fully dressed and still be sexually touched, or somebody can be undressed and sexually touched. Male and female victims, male and female perpetrators, sexual touching. A wide variety of examples of that. Kissing can be sexual touching if it's unwanted, not consented to, and considered for sexual gratification. So a kiss can be a sexual touch as well. All of this is without consent, and person under 16 cannot consent at law. A person under 16 cannot consent. So it's a sexual assault if there's no consent, or if a person is drunk or drugged or unconscious asleep, they cannot consent at law. If they're so drunk that they cannot consent, because people do get drunk and do consent, but if they're so drunk or so intoxicated by drugs that they're not capable of agreeing, then there's an issue with consent. Sexual act might be, for example, doing something to somebody else, or in front of somebody else, like masturbation. Masturbating in front of somebody without their consent is a sexual act. It might be doing something to yourself, or doing something in front of somebody else, or doing an act to asking somebody to do something, some sexual act. Okay, sexual act. For offences against people that are under 6, sexual offences like sexual touching, sexual assault, and sexual act, there is a child protection register. And people that are found guilty of these offences have to register with police, and they have to, there will be conditions. They might have to tell police every time they get a new phone number, where are they living, when they when they apply to internet, access internet, registering with an internet company, that sort of thing. They may not be able to live in certain places, work in certain places where children will be. There's a child protection register as a result of being found guilty or convicted of those sorts of charges. Consent is an agreement to do something, a willingness, an agreement to do something, a sexual act. A person cannot consent if they're under 16 and a person at law, and a person cannot consent at law if they are so heavily intoxicated or drugged or asleep. They cannot consent. Aggravated, an aggravated example of the offence might be that the person is under 16. It might be aggravated because of an intellectual impairment. It might be aggravated because it's in company, more than one person doing this offence, more than one person involved in committing the offence. They're examples of aggravation. And it gives it a higher maximum penalty, more serious. So the maximum penalty is worse. Age of consent, I said 16. So anything less than 16, at law, a person cannot consent. less than 16. There are now some special circumstances where if there's boyfriend and girlfriend within 2 years of age of each other, there might be special consideration for that. But otherwise, 16 and above, person is taken to be able to consent. But if they actually don't consent, then it's a crime. But a person under 16 at law cannot consent. Historical sexual abuse, anything, we have people that are charged with things from 1960, 1970, 1980 is historical because it's a while ago. So we have to look at what was the maximum penalty for that charge at that time. Research the law. That's historical sexual abuse or a historical sexual offence. Okay, so hopefully I've explained and cleared that up.
Yes,
And
well,
without
there's
causing anybody any embarrassment.
no. Okay, well, there were no questions there, so we'll move to the next one, which is offences.
So theft and larceny and stealing are pretty much all the same. You can steal from your employer, you can steal from the shop, you can steal from a house. They're all theft, they're all larceny, they're all stealing, and shoplifting is from the shop, but they're all removing something and intending not to give it back, not to pay for it if it's shoplifting, not to pay for it, to steal something and not give it back. So break, enter and steal is actually break and enter and commit serious indictable offence, and that serious indictable offence is larceny. So larceny carries 5-year maximum penalty. They can be kept in the local court though. Most shoplifting and everything will be kept in the local court, but it can depend on the quantity of what is stolen as to whether it's taken up to district court or not. Robbery is, there's a threat. Can be verbal, can be physical, but there's a threat with stealing. And robbery recently can now be kept in the local court as well. So there's a threat involved with the stealing. Burglary, we don't have it as a separate offence in New South Wales, but I believe it may be in Queensland. And I think, and I might be wrong, it's more the timing of it, like at night time. I think, but I might be wrong. I might be wrong. Burglary at the moment in New South Wales, that's not a charge, but we do have break, enter and steal, and that can be done at night time or in the morning, and it's aggravated if it's in the night time or nighttime. It's considered worse. It's more serious. Fraud, a huge variety of frauds. Pretending, might be using somebody else's identity. It might be using somebody else's credit card. You've stolen a credit card and you're pretending to be that person, pretending you have authority to do it. Might be a forged signature. Fraud, it's pretending to have authority or to do something that you're not supposed to be doing, to be a person that you are not really, taking somebody's identity and using it. Hacking, there's no actual crime called hacking, but we all know that hacking is like to do with the internet or hacking somebody's personal identity, pretending to be somebody else, stealing personal details, stealing bank account details, hacking, a lot of internet crime, stealing identity and using that identity to maybe open a bank account, create a new identity to open a bank account, buying things under somebody else's identity, impersonating somebody, stealing, and then using that new identity to commit crimes in that person's name. and obtaining benefit by deception. You're pretending to be somebody else, or you've stolen some property and then you're selling it at the shop, and it's not your property, you've stolen it and you're trying to get the money for it. So you're obtaining benefit, you're obtaining money by pretending to be somebody else. Obtain money by deception.
Great. Thanks, Helen. So still no questions, so we'll keep moving through on to alcohol and drugs. Hopefully that's come up now.
Yep, so illicit drug is illegal. Illicit is illegal. Illegal. So not prescription, and it's not a medication from a doctor, not prescribed, and it's an illegal drug. Cocaine, heroin, cannabis, illegal drug. Possession, I have it. I'm in possession, or it's in my house, and I am the only person living in my house, for example, or it's in my bedroom and my bedroom is under my control. If you're sharing a house, maybe 5 of you use the kitchen, and if the drugs are found in the kitchen, maybe the police cannot prove you exclusively control that drug. It could be anyone in the house, could belong to anybody in the house. So the police in that sense may have problem proving that you control it, that you possess it. So that's a bit of law that might be interesting in some cases. Possession, who controls it, who owns it, who controls it. Use, I might possess the drug for personal use, and if I'm charged with deemed supply is presumed to be in possession for the purpose of supplying or selling the drug. If I can prove on the balance of probabilities that the drug is in my possession for my personal use, and I give evidence that I am a drug user, and this is how much I use every day, and this is how much money I spend when I buy my drugs, then I might be able to be found not guilty of deemed supply, but I am guilty of the backup charge. I spoke about backup charge before. Backup charge of possess prohibited drug. So I'm guilty of possessing it, but it's for my personal use. So I'm not guilty of supplying it. I was not going to give it to anybody else. I was not going to sell it to anybody else. It's all mine. It's for me, personal use. Merit program is something that's in the local court that's like a diversionary program. So before you get sentenced, they try and divert you into a community program. Go and do some courses about drugs. Go and do some courses, get some education about how bad these are for you. Come back to court after you've completed the course, and maybe the magistrate will be a little bit more lenient on you if you've completed that course. It's a bit of rehabilitation. Driving under the influence can be drugs or alcohol. Driving under the influence of drugs or alcohol. There's a limit with alcohol, 0.05 in New South Wales, and then that's the prescribed concentration of alcohol, breath test, all of that. Driving under the influence of drugs, any cannabis, cocaine, ice, speed, all of those, driving under the influence is illegal, and there's a charge for that, and that will be dealt with in the local court. There's different, depending on how far over the limit you are, low range, middle range, high range, there'll be different consequences. The worse it is, the potential to go to jail is much higher. So if it's high range drink driving and it's raining and you have an accident and there's busy period on the road, lots of drivers, the risk of going to jail is very high. If somebody has got lots of these charges on their criminal record over the years, the risk of going to jail is much higher. They'll also have different consequences about disqualification period and fines. So 6 months, 12 months. Please don't ask me right now what those different penalties are, because legal aid, if you're not going to go to jail, our policy is the risk of going to jail. We will give you advice, but we don't represent you in court. But with high range drink driving, with somebody with a criminal record for it, history of it, and especially if there's been an accident or worse, somebody killed, you will chance of going to jail is very high. But I don't do these matters every day because we usually deal with people that are facing jail. So I don't represent people every day in these matters, but in local court, yes, you will hear these every day in the local court. But for a legal aid lawyer, we're usually representing people that have the risk of going to jail. So unless it's high range drink driving, especially with somebody with a bad criminal traffic record, then I won't usually have much to deal with drink driving charges. So I do not immediately know the penalties off the top of my head. I apologise.
That's okay. No one's asked about those. But someone has asked, are controlled or border controlled drugs the same as illicit drugs, or is there a difference? I don't.
There is a
Oh,
difference. Yep. So
okay.
Commonwealth, you can be, some things are precursors to, example, some drugs, some chemicals are precursor, or they're the ingredient to manufacturing an illegal drug. And some of those precursor substances, like pseudoephedrine, for example, is maybe perfectly legal in some countries. I think in Thailand, a lot of it comes in from Thailand. It might be legal in Thailand, so not a crime to possess in Thailand. But when it's imported to Australia over a certain quantity, then there'll be a criminal charge, that border controlled drug. And because it's a precursor here, and unless somebody has a permit, like a special permit to be buying and selling and possessing that drug. Now, some of the drugs are used in industries. Chemicals are used in industries. So somebody might have a license to go and buy a particular chemical. The chemical may have a totally innocent and legal use in a particular industry, but it may also have an illegal use in the manufacture of ice, which is methamphetamine, speed, MDMA, all of those. So if it's a precursor, it might be one of those border controlled drugs, so you can be in trouble for importing. And there are crime syndicates that get a lot of international students. A lot of you may have interpreted for people. A lot of international students get picked up. They've got no criminal history. They've come here on a student visa and they're targeted. Go and pick up this package from the post office. And the package comes from overseas and it contains pseudoephedrine. And then the student will give that package to somebody else. The student's not involved in the manufacturing. Now, some students know what's in the package and then they'll be guilty of possessing the border controlled drug. But if they don't know what's in it, then they might be not guilty of the charge. But they're often used because they've got no criminal history. They're a bit desperate for money. They're away from home. They're desperate for money. Some of them are only, they're $50, $100. It's terrible, but then they are charged with the crime.
Okay. There's a question here. What category does offences resulting in willful damage come under? For example, someone throws a rock through a window of your
Yeah,
house, and does the perpetrator pay for the damages?
probably. Okay, so destroy or damage property. Okay, destroy or damage property, and this is very common when you have domestic violence cases or even your neighbourhood dispute cases and there's an AVO, there might be a criminal charge of assault and also destroy or damage property. It might be intentionally destroy or damage property. That will be the criminal charge. And do they have to pay compensation? You can ask for that. The police may ask the court to make an order of compensation for that. Whether you get the money back is another question. Especially if they're in jail, you may not get the money back, but you can ask for an order for compensation.
Okay. And there's a question here, can you be charged with driving under the influence if you're on a prescription medication and the quantity you've taken has impaired your driving?
I think as long as you're under the influence of the medication that you are supposed to be taking, um, I think if it's impaired your driving, I guess look, it may depend on what the instructions are on the bottle or the packet as well. If you're told that you shouldn't be driving, then maybe it's negligent. Or if you're impaired and you are swerving all over the road or something, then you'll be on a different charge. You'll come to the attention of police because you're doing something dangerous or reckless. So you may there's not actually a charge for driving under the influence of a prescription medic. There's no actual charge for that. But if it is impairing the driving, then you probably be on a different charge for a start, because police will have noticed your driving is bad or driving is problematic. So they've probably pulled you over for a different reason. And then, but the test will come up, the saliva test will show up for narcotics. It'll be like, cannabis or ice or something, or the alcohol test. They might think you're driving under the influence of alcohol or drugs, but the test will come back negative because you're not. It's a prescription drug.
Okay. All right, well, we might move on. And now the offences of domestic and family violence.
Okay, so DV, domestic violence, FV, family violence, and they may be like one and the same. An apprehended personal violence order is often the neighbourhood dispute. You're not family members, but you're neighbours. Or it might be terrible workplace incident that causes, personal violence order. Or it might be some random person stalking you that ends up with a personal violence order against them. Apprehended domestic violence orders will be prosecuted by police. Police will represent the PINOP, person in need of protection, PINOP. You will hear and you will see that on the documentation. So police will represent the PINOP in court, but if it's a personal application without not police making it, but if you want to go and take an application out, you go to the local court and you take out an application against somebody. That's a personal violence order, and you have to represent yourself or get a lawyer to represent you in court for the apprehended personal violence order. Still a PINOP, the person in need of protection is a PINOP. It is not a crime to have an AVO against you. It is not a crime. However, it is a crime. It's a breaching AVO is breaching apprehended violence order is a crime, and it can be a penalty of 2 years imprisonment. So to be charged with a breach is a crime to breach the orders, and you can be charged and can be sent to jail.
Okay, thank you. So now we're going to look at sentences. So that's a good segue into this. If you want to explain the different sentences we now have in New South Wales.
Okay, so as of September 2018, we got these. These are our sentences. Intensive correction order. This is a sentence of imprisonment, but it is served in the community. So it is a term of imprisonment. It's very serious. It's like the old suspended sentence, okay, but it is served under supervision in the community, and if you commit any new offence or breach the conditions, there might be a curfew, there might be no alcohol, there might be go and see your GP to get mental health treatment. There will be conditions. One of them is being of good behaviour. Don't do any more crimes. So if you break those rules, then the parole board will decide whether they revoke or cancel it, and you have to go into jail to serve the whole thing in jail. That's an intensive correction order. Some people have home detention or community service as a part of the intensive correction order. It is 2 years or less, or if there's more than one charge, like 2 or 3 charges, the magistrate or judge can give you a 3-year intensive correction order or less. Can't be more than that. But it is a jail sentence, so it's important to remember. Community correction order is not jail. It's not a jail sentence, but it is a conviction. And it's like a good behaviour bond. And you may have to be supervised by a community correction officer, which is a parole officer, or may not. You'll have some conditions. You may have to go and see a doctor. You may be banned from alcohol or drugs. You may have various conditions that you have to obey. If you break the rules and you get caught breaking the rules by police, or you do a new offence, commit a new crime while serving the community correction order, then you have to go back to court, not parole board, court. You have to come back to court, and the judge or the magistrate will consider whether to cancel and give you a worse sentence or not. So you are convicted, but it's not a jail sentence. Conditional release order, again, not jail, and it's meant to be for less serious. You'll see this more in the local court, less in the district court. Okay, this will be less serious offences. Again, you may have some conditions to follow, and if you break it, you have to go back to court. You can be fined, so people can still get fined. You'll see this more in the local court than a judge in the district court giving somebody a fine. But the fine, and you usually have 28 days to pay, and or you can apply to pay by instalments if you can't afford the fine. Section 10(1)(a), this is charges dismissed and no criminal conviction. So you are guilty, but your charge is dismissed without a conviction. And 10(A) is you are convicted, but with no further penalty, no jail, no fine. Conviction, it's noted you are convicted, but there's no other penalty other than a conviction. So they're the sentences. And of course, there's prison.
Oh yes, of course.
there is prison, full-time prison.
That's right. Okay, well, we'll talk about sentencing discounts now and why they're important with interpreting.
So when you're interpreting in conferences and in the local court in particular, you will hear this. So if a person pleads guilty in the local court, they may be eligible for 25% discount off their sentence, which we're usually talking about a prison sentence, off the prison sentence. This reduces and disappears if you plead guilty later. So if the plea of guilty is entered after you've left the local court, so after you've been committed for trial, then you change your mind and you decide to plead guilty. If you plead guilty more than 14 days prior to the trial starting, then you're eligible for a 10% discount off the sentence. If you plead guilty less than 14 days before the trial starting, so it's getting very close to the trial now, then you're eligible for a 5% discount off sentence. They're really encouraging people to plead guilty early. So don't set trial date if you're not going to end up going to trial. They're trying to encourage people to plead guilty in the local court, and the reward is a 25% discount on sentence. You will hear this told to the client. Lawyers have to explain this to the client in conference. The court will speak about it, what discount, and the judges are now, this is the legislation, sentencing legislation, and there's no choice. Like, judge can't give somebody more than 10% discount if they plead guilty on the first day of trial. Judge cannot give somebody more than 5% discount if they plead guilty less than 2 weeks before the trial. The judge has no choice anymore. The legislation says this is the rule now. If a person, for example, if somebody's got a sentence carrying life imprisonment and that's going to be the penalty, then it doesn't matter if they pled guilty in the local court. They will not, if they're going to get life imprisonment, then there's no discount. They're going to get life. But very few people do actually get life imprisonment. But charges like large commercial quantity of drugs and murder do carry, and child sexual assault child under 10, those charges do carry life imprisonment as a maximum penalty, but not many people actually get life imprisonment. But that's just something to be aware of, yeah.
Thank you. Someone's asked a question about, on the previous slide, you talked about 10(1)A sentence. Is that only for first offenders?
Usually yes, but not always. It really depends on the charge, depends on the magistrate or the judge, and it maybe if there's been a big gap in their offending, like a long time where they've been really good and there's been no convictions, maybe you would get another one.
Okay. So we're very close to the end. So how about you tell us about how sentences are structured? I think you've talked about this.
Yep. So I did sort of the non-parole period and the parole period, 75%, 25%. So, yeah, so I think, and I discussed special circumstances, trying to reduce that non-parole period, have your client have less time in jail. Maybe they're old, maybe they're young, maybe they're ill, physically or mentally, those sorts of reasons, trying to reduce the time in jail and increase the time on parole.
So this next slide is actually talking about mental health and how that impacts on sentencing, but also where these matters are heard, if you want to go through that.
So I'll start with the right-hand side because that's the local court. The Section 32 is you have a treatment plan for somebody. Psychologist or psychiatrist has a treatment plan for somebody. They've got a mental illness or some sort of a mental condition that needs treatment, and there's a plan in place, and you give that report to the magistrate. This can only be done in the local court, and it's not, they've done the crime, but they're not going to be convicted of it. They're discharged under Section 32. If they fail to go to their doctor, fail to do the treatment plan, then they can be brought back to court to be sentenced or to be dealt with other than law. If the magistrate thinks the charge is too serious to be dealt with under Section 32, they can reject the application and just sentence the person, but still take into account these mental health issues, because mental health is relevant on sentence as well. Section 33, and this is the Mental Health Forensic Provisions Act, and this is changing soon. So I think next month or the month after, there are changes coming to this legislation. So later on in the year, when we present this seminar or something similar again, there will be some changes to the section numbers perhaps as well. But so the Mental Health Forensic Provisions Act is changing. Not guilty on the grounds of mental illness is something that is dealt with in the higher courts. So the person has committed the offence. There's no doubt that they did the crime. However, because of their mental illness, at the time of the offence, it affected their thinking, so much so that they either didn't understand what they were doing, or they believed that it's right, that they felt justified in doing it because of their mental illness. So they may have a defence of mental illness available, but to get that defence, you need an expert opinion on it. You can't just go to court and say, Your Honour, not guilty on the grounds of mental illness. There needs to be psychiatric evidence. There needs to be a report from an expert who assesses the client and looks at their whole medical history and all of that, looks at the circumstances of the offence. So you're not found guilty, you're not convicted, you're not given prison, but you are possibly detained in a hospital, mental health hospital, or in prison waiting to get to a mental health hospital. And you are reviewed by the Mental Health Review Tribunal, the MHRT, and some of you may interpret at the tribunal. Those are civil hearings after a criminal case. And the Mental Health Review Tribunal also deals with guardianship and people that can't take care of their own finances because of mental health or intellectual impairment. So a lot of you may interpret at the tribunal. Fitness hearing can be local court or district or Supreme Court. The consequences are different in each court, but I'll talk more about district and Supreme. Person's unfit for a variety of reasons. They can't understand what they're charged with. They can't give their lawyer instructions. They're really unwell mentally or intellectually. They're really unwell, and at the moment they can't comprehend things. There might be signs, they're asking their lawyer the same thing all the time. No matter how many times the lawyer tries to explain it, it's not being understood. So they may be unmedicated. They may improve with medication. They may improve once they start getting medicated or not. Somebody with an intellectual impairment may never improve their level of understanding. So if they're unfit, then the court will send them to the tribunal to see whether this person is likely to become fit with time and maybe with medication. Will they become well enough? If not, they come back to court for what's called a special hearing, which is in the district or Supreme Court. It's like a trial, but with no jury, and the evidence is told to the court, presented to the court, and the judge makes a determination. Are they not guilty entirely, or are they not guilty on the grounds of mental illness maybe, or are they guilty but they don't have a mental illness defence available? And then if they're guilty but without a mental illness defence available, then how long should we keep them? If they're in jail, how long should we keep them in custody? And they're reviewed every 6 months by the tribunal. They're reviewed every 6 months by the tribunal. Are they getting better? What's their mental state now? Where should we keep them? Is there a bed available in the forensic hospital? That sort of thing. It's quite complicated, this area. It's quite difficult for lawyers as well to understand, and it's a very slow and long process.
Okay. Well, Helen, that's been a marathon effort, getting through all those words. And then, of course, we have these words that are American words and we don't use them in New South Wales.
Yeah.
So is it worth even explaining them, or just letting people know they don't,
You may hear these. Yeah, we won't be using these.
In court, misdemeanor, first, second degree murder.
An early release for good behaviour does not happen here. You have to be good to get out on that minimum, that non-parole period expires, then you're eligible for parole. But you don't get a bonus, don't get out earlier for behaving in custody. The idea is you should behave, or you may not get out when you're eligible for parole.
Yes. Okay, or plea bargain. We won't hear that in the
Yeah,
courts.
no, we do negotiate, but we don't plea bargain. Yeah.
Okay, thank you. Well, we apologise that it has we have gone way over time, but hopefully you've found this useful. Certainly, people have had to go have said it's been amazing. Someone has asked a question: what about restraining order? Well, that was when we talked about AVOs, wasn't it, Helen?
Yes, yeah, that's right. So, anything
Um,
particular? Yeah, you want me to?
no, they just said, what about restraining order? Is that an
Yes,
American term?
yeah, yeah, it kind of is, but you will hear it here, I guess. But just usually, yeah, we'll um, it just be the ADVO or the APVO preventing
Yeah,
somebody from doing something. Yeah.
yeah. Yeah, so just want to thank everyone for listening to this webinar today about legal words for interpreters and bilingual workers, but focusing on crime words. If you're interested in finding out about any of the Legal Aid New South Wales publications or other webinars, you can find those on our webpage on our website. Go under workshops and webinars and you'll find all the information. After we close the webinar, you'll get a survey. We appreciate your feedback. And also there'll be an email following up with some links to resources which you can help you with interpreting crime words and a certificate of attendance. And next week, we'll have the recording of this webinar up on the Legal Aid New South Wales YouTube channel. And if there's any questions after watching that, you can send those to the Legal Aid Community Legal Education team and we'll forward those on. You're getting lots of thank yous, Helen, for this wonderful
I just
webinar.
want to
And I
thank
think,
I just want to thank all of you for your job in court, in conferences, helping us lawyers to interpret by interpreting what we're saying to our clients and what our clients are saying to us. Because without you, I can't communicate properly with some of my clients. I can't speak their language and they can't speak my language. So, thank you. Your job is so important, and we really acknowledge and appreciate the skill that you bring and the assistance that you give us.
that's right. That's a very good, excellent point to finish on. And I'd just like to thank you, Helen, for all your time today and sharing your amazing knowledge about all these words that are used in criminal law. I've learned so much today. It's been fantastic. So
My pleasure.
I don't think there's any questions. Everyone's just saying thank you and that they've learned an amazing amount. And
But feel free, I can answer some questions by email. Like if you think of something, if I haven't explained something to your satisfaction, send an email and I can get to you as soon as I can with a
yes, and
response.
we'll review the questions that were written in case I missed some today. And if there's any particular Helen can respond to, she'll send you an email in
I
reply.
will.
Yeah, so all the best, everyone. And thanks again, Helen. We'll see you next time.
Definitely. Thank you, Kerry. Thanks very much.
Okay, bye.
Bye bye.